Well, welcome back to the Cordell and Cordell Virtual Town Hall. I'm Scott Trout, your moderator, managing partner and CEO of Cordell and Cordell. And as usual in our virtual town halls, we're joined by a panel of Cordell and Cordell attorneys from around the country, and today is no different. And today we're going to be talking about something very important. We haven't spoken about it during the year that we've been doing this, and that is divorce and retirement, and what we are to do with that and how we treat it. And all the complexities that are associated with it. Keep in mind, we'd love to hear your questions. Some are already coming in as we go. You want to submit those in the Q&A section. We'll address those questions in the second half of our town hall today as we get through our topics for today. But if you don't want that addressed today, but you want to submit it, and we can address it in future town halls or our weekly podcast that we do it, you can send those to townhalls@cordelllaw.com. That's townhalls@cordelllaw.com. So check us out at cordellcordell.com, follow us on social media, and also look forward to the next town hall coming up in April. You want to get registered for that, and also subscribe to our weekly podcast. We do it twice each week, and you'll get the similar information, but over about 10 to 15 minutes on each subject. So again, we're going to be talking about divorce and your retirement savings and all the variances that are in that and what types that we have. And always keep in mind, that this is not legal advice. We don't want to establish an attorney-client relationship. We'd love to have a consult with you. That is the only way for us to really give you solid direction, strategy, and advice is by setting up a consultation. You can do that at 866-DADS-LAW or going to the web at cordellcordell.com and checking out that we have an office near you around the country and including the UK. So give us a call. Happy to do it via Zoom, in person, on the phone, or whatever is appropriate for you. Considering your circumstances. So let's get to our panel. Then we're going to take a break, and then we'll get right into our topic for today. So we have a few repeats joining us, but today is Melissa Taylor up in Edina, Minnesota. Welcome, Melissa.
Hi, Scott. Thanks for having me back. As you mentioned, I'm from Edina, Minnesota. I've been practicing for about 9 years with the firm for the last 5.
Thanks, Melissa. Joining us in the Salt Lake City area is Zacchary Sayer. Welcome.
Hey, thanks, Scott. Happy to be here. I'm Zacchary Sayer. I've been practicing family law since 2016. And this is my first time on the panel, so I'm happy to be here.
Great. Thanks, Zacchary. Joining us up in the Allentown, Pennsylvania area, Cara Phillips. Welcome, Cara.
Hi, Scott. How are you? Cara Phillips from the Allentown office, as you mentioned. I've been involved in the practice of family law for roughly the last 5 years, and I've been with Cordell for almost 2 years now.
Thanks, Cara. Rounding out the panel of Cordell attorneys for today is Chris Randle in Wichita. Welcome.
Hi, Scott. Thanks for having me. Like Scott said, I'm Chris Randle from Wichita, Kansas. I have been working on family law issues for military members for about 15 years, and I've been with Cordell since 2019.
Thanks, Chris. Well, as you can see, we have attorneys from around the country. They'll give you a different perspective, and you'll see some of the issues in which we address. They'll bring their level of experience with that as well. So keep in mind, we're getting questions as we go right now. Submit those questions in the Q&A section. We're going to get to those in the second half of our virtual town hall where we'll address those. And if you'd rather just submit it via email, we'll get to that in the weekly podcast or in next month's virtual town hall. You can submit those to townhalls@cordelllaw.com. So we're going to get started here in just a second. We'll be right back after these words.
Even in the toughest of times, there are usually opportunities for relief. Many husbands and dads listening now are struggling to stay current on alimony and child support orders. You should know that this crisis may allow you to modify your support obligations, but time is of the essence. If you're a guy needing help right now, not someday when things are back to normal, call us at Cordell and Cordell. This is what we do.
All right, welcome back. Let's get started. Let's dive right into retirement, and we can start right off the top with, I think, can be one of the more challenging areas of retirement to deal with. You always want to find an attorney who practices exclusively in family law. And in this topic, particularly, we're going to talk about military and VA retirement benefits. And that's one where if you don't have an attorney that has dealt with that, that probably is a mistake. You want to make sure that you have someone who has a knowledge with that, experience with it, because there's some complex issues and way to handle it, especially when it comes to the division of it, not just the administration of it. So Chris, I want to talk and turn it over to you. And there's something called the High 3 system. What's that being replaced with? Maybe just give everyone an intro into that and we'll kind of go through it.
Sure. I think, Scott, what you said about having an expert or someone that deals in military issues is very paramount because they're kind of complicated issues. A little bit of background on myself. I mean, I can tell you that not only am I expecting a military retirement as an Army reservist with prior enlisted time, but I'm also a disabled veteran as well. So on top of Army retirement and on top of I will be getting VA disability. In regards to the High 3, so a few years ago, about a decade or so ago, Congress had looked at the military retirement system and its costs on the taxpayer. And they also noticed that if you were a service member and you didn't make it to 20 good years of service, that you really walked away with no retirement. For example, if you're a service member who was in 15 years and you left, you walked away with nothing from the military. So they came up with a solution from the High 3 system. And the High 3 system is simply this. At the end of 20 years plus of good service, the highest 3 years of pay is what your pension is. At 20 years, you get 50% of your highest base pay for 3 years, and then every year it adds a certain percentage. Well, now they came up with what's called the blended retirement system, so it's a little bit different. So it's a percentage of your best years, plus you have the option to put a certain amount of money in a thrift savings plan, similar to like a 401k that the government matches. So it's a little bit different. I fell in when I came into the military the second time in 2005 to where I had the option of either staying with the High 3 system or going with the blended retirement system. For all of those service members coming in now to any of the Department of Defense divisions, they have to go in the blended retirement system. So a retirement before, so for example, if a service member under the High 3 system got divorced after, say, 8 years in the military, dividing up his retirement was not really a great idea because that service member, he or she, may not ever vest in a retirement. Well, now, once you come into the military, you vest immediately with something. So military divorces are really going through a very, very big change for the first time in literally decades.
Yeah, and it is, as you suggest, and I mentioned, it is complicated because of the transition, how to deal with it, what is divisible, and what do you do? And let's talk about the VA benefits in a divorce. Are they not divisible? Can you divide them? What can you do, and how do you calculate them when you're considering it? Because a lot of the military wants to know, what's going to happen with my benefits as I get divorced.
Absolutely. Great question, Scott. And I will tell you that VA disability benefits are becoming a very, very prescient issue because of the multiple deployments, obviously the war on terror, and just the very high cycle of deployment you have for both active duty and reserve service members. So the deal with VA disability is the Supreme Court specifically wrote that VA disability payments are not divisible in a divorce. However, they are allowed to be calculated for purposes of child support and spousal maintenance. So although they're not allowed to be directly or indirectly divided in a divorce settlement, the court can take VA disability into account when it comes to determining support for other persons, children, or spouses. Now, there's another little nuance with VA disability, and that is that when you are under 50%, if you retire from the military and you get VA disability, if your award was under 50%, so if the military or the Veterans Administration said you are disabled at 30% and you retire after 20 years or into the blended retirement system, it's really a wash because your VA disability of 30% replaces the military retirement. Now, the important difference here is that if you are over 50% disabled, then you get the disability payments on top of your retirement. Now, to complicate this issue even more, then you get into the issue, well, what if you have a service member who has been in over 20 years, has a military retirement, and their VA disability benefits are 30%? So then you get a situation where you have the VA paying part of the retirement and the military paying the other part of the retirement. The problem is that the VA portion, which is now offset the retirement, is not divisible in a divorce. Now, we could kind of go on to some of the nuances in case law, but I wanted to keep it broad enough. But I hope that people who are in this situation understand how complicated and how many moving parts there are and how important it is to get an attorney that is versed in this area and understands a very difficult minefield.
It is. I mean, it's like anything, or you mentioned not divisible. There are common retirement systems like teacher retirement. For example, in Missouri, teacher retirement is not divisible, but you can use it for determining spousal support and child support because it is income from whatever source. And that's kind of the IRS definition. And it is complicated, whether you're a government employee in the civilian world, where you have multiple variances of retirement system. In the judicial sector, they also have multiple retirement benefits. So it is complicated. Having an attorney knowing and being able to navigate it, not only telling you as the client what is and what isn't divisible, but then being able to actually do it and making sure it's done appropriately. So Chris, thanks for that input. I want to turn to Melissa real quickly. Let's talk, Melissa, about the differences, because many watching now, they interchange. We did a podcast recently on this with one of our attorneys up in Indiana. And the question really was, people use retirement interchangeably, and it could mean a pension that has a direct contribution. It could be a pension that has no direct contribution. It could be an IRA or 401k. So maybe let's talk about the different types of accounts that people will see typically, and what is really commonly divided, and we'll kind of go through all of those.
Sure, I think that makes sense, Scott. So why don't we start with 401ks? 401ks seem to be one of those most commonly divided, useful retirement tools that we use when we're dividing property. So 401ks are really good when we're dividing property between people because you can use it versatily. So for example, if you have a house and you've got equity in that house, but somebody really can't refinance, doesn't have the ability to do that, you can take retirement dollars and use those to be able to kind of offset what that property would be. So you can use it just in terms of being able to provide a equitable division of property, that equity payment essentially. The good part about 401ks is even if you are transferring it to another person, if it's incident to a divorce, for the most part, people will pay taxes on it if they pull that money out, but that 10% penalty won't apply. So it's a really good tool for us to move money around for people in a divorce situation, especially if you have a really large retirement account and not a whole lot of cash. That's a good way to move money around between people. The other thing too is, people have good retirement accounts. People do put contributions into their 401ks. And so if you have a spouse who hasn't been doing that as much, you can roll it into an IRA, and then the person receiving that money can just leave it there, and then they actually can build their own little nest egg that they can use down the road that they need to.
It is, I think, a common, one of the things, sorry to interrupt you, one of the common misconceptions about retirement, let's just take 401k, is that I get it a lot. I don't want to pay taxes. I mean, I don't want to divide it because I'm going to get hit with taxes and a penalty. And his understanding, as you mentioned, and I think the key words were incident to a divorce. And that's what the IRS code is allowed, is that if you have an agreement, a divorce, a separation agreement, and a judgment of dissolution, there are no taxes on the division unless someone actually pulls it out of a qualified account or an IRA, right?
Correct. Yep. So like I said, if somebody wants to roll it into an IRA and just leave it there, then there aren't any tax consequences associated with that. But if that person who's receiving the money then wants to pull that money out, yes, they would pay taxes on it. But like we've talked about, they wouldn't have that 10% penalty, which is really big. If it's incident to a divorce, you don't have that.
There's some really useful strategies, and I think I've addressed some of them early in last year about techniques to avoid or trading property, trading support for more money out of the 401k. And it's one of those things where I think if you look at the giant picture, rather than categorizing each and just saying, okay, 50-50 here, 50-50 here, and accordingly, you can use the 401k to try to equalize property or negotiate away, right?
Yes, absolutely. So like I was saying, if you have a cash asset where there's not really an ability to pull that money out, you can use that 401k. Now, obviously, there are tax consequences to that 401k. So you want to make sure that you're taking those into account, and your attorney should be able to help you do that so that you're comparing apples to apples, because obviously cash is cash, and retirement does have some tax consequences. So when you're taking $50,000 out of a retirement account, it's not necessarily $50,000 in cash.
Mm-hmm. That's a huge point. And I mentioned this earlier in the year, and that is at Cordell, we have a tax and benefits department. And one of their jobs is to analyze that. It's the understanding of, if we divide everything 50-50, but yet the spouse gets, let's say, tax-free or tax less ramified property, meaning that they may get something that they'll never pay taxes on, yet you take all of your 401k, which ultimately you will pay gains once it's withdrawn. You may not pay penalties. So it's not dollar for dollar. Not all property is equal when it comes to that. And I think that's an important part, is to find a lawyer where, again, like military, like this 401k, that has a department, that has someone on staff that can do an analysis and say, okay, you're going to take 50,000 in the 401k, she's going to take 50,000 in the equity, but those dollars aren't equal, because you're going to pay, let's say, 20% tax rate or something, whatever the gains rate is at the time. And so I think that's a huge point for people when they're considering dividing their 401k, is understanding, as you point out, the tax ramifications, not in the division, meaning put that aside, we'll divide it pursuant to the judgment, but ultimately when you retire, what is that really in dollars? What does that mean to you in the net? Because you will be paying tax. So I think that's huge. So I know you'll talk a little bit about, we divide these via a quadro vehicle. I know Cara's going to talk about those a little bit, but that's really the mechanism to divide the 401k, right? A quadro?
Correct. It's a qualified domestic relations order. And so it's a separate court order, separate from your judgment and decree, that we would use to actually divide it. And that order goes to the plan administrator, who then separates all the funds out. So kind of to the cost piece that you were talking about, that also has to factor into your considerations of, yeah, it's easy to get cash out of one thing, but like when you refinance and you have the closing costs, to do a quadro, you also have fees associated with that, fees that come from the plan. And so those also need to be factored into decision making as well.
So the next type is pensions. We talked last week in one of my podcasts. It'd be a very interesting one to find. We talked about the difference between defined benefit and defined contribution. But pensions, people throw that around. Oh, I don't want anybody touching my pension. Well, it could be a 401k, but there are really specific types of pensions, right?
Yes, and pensions are a touchy one for a number of different reasons. But one of the biggest things is it's difficult to determine the actual value of your pension as it sits right now. So if you're looking at your pension statement or your retirement statement, what's listed on that statement isn't necessarily what's sitting in that account. There's present value considerations to consider. So there are ways for us to do that. Typically, it means we may have to get some sort of a pension valuation to see, okay, when you do retire, because ultimately the benefit you're going to get isn't that lump sum payment right now, where 401k, you can kind of see that. It's that value that's down the road. And so when you're looking at a pension statement and you're talking, are we dividing this? Are we not? If you're talking somebody that's been in their field, in their industry for a really long time, and they have a very large or significant pension, or some pretty great pensions like a 3M pension, those types of things, we do want to value those for the most part, because what you're looking at, this big chunk of money, is going to be, valuable down the road. And so we want to see, is there a portion that belongs to you from pre-marriage? In Minnesota, that's a consideration that we have, is something that's non-marital versus marital. And then, looking at it down the road and saying, how much is it actually going to be worth when it's down there?
Yeah. Typically across the country, there's a formula to determine marital versus non-marital, and it's usually a number of years or number of months married over the number of months employed, and that's your fractional marital interest, at least in Missouri. So that way you determine what the marital portion is. Unfortunately, you can't dig any deeper. We've had a number of good, significant months of growth during this recent past, and so you can't really parcel out if you're actively contributing to the 401k. Well, my premarital portion was where it grew the most, and now the postmarital isn't where it grew. You really don't do it. You usually typically use that type of formula. But let's go to IRAs in terms of another vehicle that is commonly divided, right?
Yes, IRAs are also divided. The difficulty with IRAs is you have the traditional IRA and you have the Roth IRA. So the traditional is the pre-tax IRA account, and then the Roth IRAs are the post-tax account. So just like 401ks now also have the traditional and the Roth version. There's different tax consequences depending on which type of account you have. Generally speaking, IRAs don't need a qualified domestic relations order to be divided. Sometimes you can just transfer them from an IRA to an IRA, but it does come up from time to time. So you're going to want to make sure that your attorney has a chance to look into that and see, are there tax consequences, or does it need a QDRO in order to do it? And the other thing to think about too is, where is your IRA sitting? Different companies have different policies in terms of what they allow you to do and what they don't.
And it's not uncommon for some workers to have both a 401k and a cash pension on the same statement. So are there nuances or difficulties with that?
Yes, absolutely. This actually came up with one of my clients very recently, where on the banks or on the retirement statement, it said, in big bold letters, here's the amount that he had in there. And so when we were looking at that, we were saying, okay, well, is that the total amount that's in his retirement account? But actually it was broken into two separate accounts. So one of them was the 401k, and then it'll have like a cash pension account. And those are two separate accounts. And so if you're dividing those, that's going to mean that you need two separate qualified domestic relations orders for the most part. And then as you're talking about who gets what in terms of retirement assets, do you want to take it all? Whoever's getting that money, do you want to take it all from that 401k, or do you want to do two different QDROs, in which case you're going to incur the cost for those? So you can kind of move it and be able to take all of it from one account if there's enough in there, or if you just want to do it completely equally, you say, we're going to take X amount from the 401k and then the other one from the pension, but that's going to mean two separate divisions.
So, I guess the moral of the story is understand what you have, the type that you have, knowing what we can or should do with it, or negotiate with it. It's really hugely important, is to kind of identify the types. Even if they're on the same statement, they may be required to have separate actions. So thanks, Melissa. Cara, I'm going to go to you, but as a reminder, we've got a bunch of questions coming in the Q&A section. Submit those now. Just in a few more minutes, we're going to be addressing those questions with our panel. So Cara, let's talk about QDROs, these qualified domestic relations order or domestic relations orders, how we divide them, particularly because it's important for clients or people going through this process to understand what it is. So maybe talk about the beginning of the process, what's entailed with a QDRO.
Right, Scott. And I just did want to mention, following what Melissa was saying about pensions, because this came up in our office this week. Pensions, typically when they're divided, you can't take your part of the pension until the person who holds it is taking it. However, there are some pensions that give the person the option to take before the person that holds it. And that came up in a case actually in our office this week. So I just wanted to mention that because we had never really dealt with that before. And you can get a court order or a QDRO to say, if you're receiving that benefit, that you can take it before the person who holds the pension is actually receiving those payments.
Yeah. Let me real quickly on that subject before we move on, because it just came to mind. That's something that you should ask your attorney about, and that is surviving spouse benefits. That's a huge one, and it's a real big property right that a lot of people overlook and a lot of attorneys completely overlook. And that is something where you can make an election if you're taking from another pension, or they will make an election. So look for that in QDROs, look for that in settlement agreements. If they're electing surviving spouse and you have the pension, it may decrease your benefit. So just something to look out for. It's very complicated. We're not going to get into it, but just important to note. So sorry to interrupt you, Cara. Go ahead.
You're okay. Thank you. So when we begin the process of dividing retirement plans, pensions, 401ks, IRAs, all of that, we start obviously with the settlement agreement or the court order. So we have the settlement agreement or order from the court saying, our client gets X amount from this 401k. And so then we go, and luckily Cordell has a team of attorneys that are fantastic at drafting QDROs, and they really, I think, specialize in them because their focus is on what language needs to go in there, what kind of tax consequences would happen if language wasn't in there, and all that sort of thing. And so once we get that settlement agreement, that's kind of the catalyst to then getting that QDRO drafted. And like Melissa said as well, part of that settlement agreement is also figuring out who pays the fee for that QDRO. So, oftentimes I see it split. Sometimes I see it, the person that is losing that kind of benefit, I'll say, pays it. But, there's all different ways to kind of do that. And once the QDRO is drafted, it's just specific language, like I said, that has the tax consequences and all that is laid out in there. so that there's no kind of confusion on that.
Yeah, the QDRO process, I mean, I typically will recommend to our clients, if we're the one that is receiving the benefit, I want control of the QDRO. I want to make sure it's drafted appropriately. I certainly don't want to do it if the spouse is getting it. I don't want to put ourselves on the hook. Let them do it. Let them incur the cost. It is a nominal cost in the grand scheme of things in order to get it done correctly. And it does. Each one is particular. Every administrator may have a different route of going in, and they may give you a nice form that you can use or some language that they want inserted. But it's extremely important, I think, as Cara's pointing out, for your attorney to take care of that and even start the process. One of the things I like to do personally is contact the administrator early on before the case is even resolved, get the language, get what they're going to need from the attorney so that we can be prepared to start the drafting right away and no delay. Let's just get it done. By the time you're done with this process already, you're exhausted with it. You don't want your attorney to see your attorney ever again, probably, hopefully, and let's just get it, completed. So once that approval, once you get it drafted, Cara, do you have to present it to the judge, or how's that approval process happen?
Right. So once it's drafted, we typically take it to both the client and opposing party, just because there is some information in there that we want to verify before we give it to the court or the plan administrator for pre-approval. And once they okay it, that's when typically what I do is I send it to the plan administrator first for pre-approval, because you never want to run into the issue where you get it filed with the court, get the certified copy, send it to the plan administrator, and they kick it back, because then you run into having to amend the QDRO, and it just takes a lot more time and money that way. So sending it to the plan administrator for pre-approval, I think, is one of the steps that everyone should practice. And so, yeah, so we get it pre-approved, and then once that happens, we send it to the court for filing. I'm in Pennsylvania. Every county is different, really, on how you file QDROs and get them certified. So typically in Lehigh County, where we are a lot of the time, we file them, and then the court will sign off on them, and then you have to go and get a certified copy of it. They won't send it to you, which is fine. And then we send the certified copy out to the plan administrator, and the plan administrator kind of takes it from there.
So I think you alluded to it earlier, Cara, and that is dealing with what I will call qualified retirement plans like 401k is different than dealing with pensions. And you mentioned that it's that sometimes you don't start drawing right away. I've got a client right now where the spouse is not yet ready to draw. It's about 7 years away. And so we're treating it a little bit differently. There's no actual division right now, but you were going to allocate how much or what percentage of the ultimate payment that the client will get. So you treat them differently, right?
Correct. And I think the biggest thing to remember about 401ks and IRAs versus pensions is that obviously you get that lump sum of money right away. Most of the time, clients will get that rollover placed into their own retirement or IRA account. And that obviously protects them from having to pay taxes right away, which is good. With a pension, I mean, I've seen pensions before where you can get an entire lump sum. But most of the time, if the holder of that pension is getting a monthly payment, even though you're getting, a percentage, like you said, or whatever it may be, you're still only getting a percentage of that monthly payment. You're not getting a lump sum as soon as that person is actually, starts receiving that pension benefit.
Yeah, and sometimes it's delayed. You're out of control until they start receiving it. They may have an early retirement age, but they can elect to retire at any point and delay it until they actually start, receiving it. And so there's nuances with each pension they just need to be made aware of. And I'm going to get to Zacchary here, but first thing is we were talking about dollar amounts and lump sum, and I mentioned this in my podcast last week, and that is to avoid the idea that you should be paying out a dollar amount out of your 401k, meaning that there's this compulsion to say, okay, I just want to give her $10,000. That's the division. I think the problem is the delay between signing the divorce, getting the QDRO approved, and paying out may be disastrous. I've had clients where I've seen I'm the second lawyer in, they agreed to a specific dollar amount. They came to me because what they're telling me is, look, I agreed to pay $50,000. There's only $50,000 left in that account because we hit a huge downturn in the market. There's nothing we can do. When you put a specific dollar amount in, it doesn't account for gains and losses. That is a huge problem when you divide 401ks is I don't like to use dollar amounts. I try to resist that temptation. I think percentages and then plus or minus any gains or losses as of the date of the dissolution, valued there and then thereafter until the QDRO is approved. That's huge, don't you think?
I completely agree with you. And the QDROs that come out of our firm, all the ones that I've seen, have all accounted for gains and losses. It's really the easiest way to make sure that you're getting, the amount that you rightfully deserve and are obligated to get. To be able to put it as a percentage plus gains and losses, you don't know what the market's going to be like in a year. So realistically, if you put a number, it could be down, it could be up. And you don't want to take that risk. So you always want to make sure that it's spot on with what you actually have in the pension or the plan.
Yeah. I've had clients want to take the risk and they think they can game the market and say, oh, I'm just going to give her 10,000. I know I don't want to give her gains and losses on it. And as long as they're fully advised as to what can happen with the fluctuation in the market, especially right now, we got ups and downs like crazy, not just straight ups. So just a word of caution. So we get to our last part of the first half. We're going to talk to Zacchary in just a second. Don't forget, submit your Q&A questions right now. We have a number of them we're going to get to here shortly. So Zacchary, diligence, timeliness, getting the QDRO completed. I've seen the horror stories where we're second in, where lawyers just take too long to get this thing done. Years. I mean, I've had clients come to me years after the fact. So let's talk about diligence. Why is it important to get this QDRO or the division of these accounts done quickly?
Yeah, thanks, Scott. And I'll just reiterate a few things as I go. One, especially the importance of not just being diligent with time, but being diligent with your research and the language specific to each account. So for example, I have a case right now where this is after the divorce. The client has a divorce decree that specifies a certain division, but the account names are wrong and the plan names are wrong. And the way they're organized in the decree of divorce isn't actually enforceable because they didn't, whoever prepared the decree of divorce wasn't diligent. And so there's no way a QDRO can be prepared based upon that decree of divorce. So as far as time goes, every state is going to have a statute of limitations. And in Utah, the statute of limitations is 8 years. And when I say statute of limitations, I mean, a court wants finality to a divorce or to pretty much any judgment. They don't want to award someone, let's say $10,000 and then have that person wait 20 years to enforce the $10,000. So they put basically a time limit. And in Utah, it's 8 years. Other states probably a little bit different. But let's say, for example, there's someone who one of the preeminent cases in Utah, the parties were divorced in 2000, and there's an 8-year statute of limitations, and the person waited until after 2008 to try to file or to try to obtain a QDRO. And what that does essentially is if you wait beyond the statute of limitations, you risk not being able to get any benefit at all because you've waited too long. Yeah. And that specific case was interesting because this is actually a case I was on. Fortunately, there's a law in Utah and probably elsewhere where if the statute of limitations can be broken down. So for example, with a pension, a person technically isn't, and again, it depends on the type of pension, but a person isn't entitled to receive the pension benefit until he or she retires. And then each pension payment, if they're doing it in sort of a payment plan where they receive their pension every month, each payment would have its own statute of limitations. So fortunately, in this case I was on, we were able to secure her as the alternate payee for that pension, her benefits going forward. So she was able to receive the benefits going forward because the statute of limitations hadn't begun to run yet on each payment, but she lost years of payments.
Yeah.
And then another reason, not just the statute of limitations, but in Utah, once you file for divorce, the court issues what's called a domestic relations injunction. The domestic relations injunction precludes either party from moving stuff around, right? So let's say I have $50,000 in some IRA. As soon as someone files for divorce in Utah, it's just going to sit there. And if someone tries to move it, then I can be held in contempt of court. But what happens after the decree is entered? Even if the decree of divorce awards a portion of the IRA to the other party, technically, that person, if the person is nefarious at all, might try to move that money, and he could be held in contempt later on for not executing the decree, but the domestic relations injunction isn't there. So that's another issue. And then in addition to the timeliness, let's say in the interim, when you're waiting to perform or to prepare the QDRO and submit the QDRO to the plan administrator, let's say the participant or the participating party in the plan dies. There are cases where we've prepared a QDRO and submitted it to the plan administrator, and the plan administrator says, "Oh, this doesn't even exist anymore."
Mm-hmm. Yeah, it's huge. If you have a property, right, assert it. Don't sit around and wait. I mean, that really is the key here. And I've been on the other side where clients come in, it's their 401k, their spouse never did anything to divide it. And at that point I was like, well, let's just sit around and let's just see what happens. Let the statute run, because that's the point, as you mentioned. The entire reason for the statute of limitations is don't sit around on your rights, assert them. I mean, that's huge. And I think that's why we put a priority about getting the QDRO done. If it's our right, if it's something we need, we want to assert and protect the income stream that's going to come forward. I know that a lot of people are looking forward to the end of the divorce, but you want to make sure that you do assert it. And it's just huge. There are so many problems, as you suggest, that accumulate as a result of waiting, that it's not worth it. Especially losing that right, that thing that you work so hard for to divide, could just go away because of time. So, all right, I know we're running out, so we've got a lot of questions that have come in. So not to cut everyone off, but that leaves us a good about 20 minutes to start answering some of these questions. So let's get to those right now, and we're going to throw them to our panel as we go through them. So let me pull them up here, and you can keep submitting them as we're going through, and hopefully we'll get through all of them today. So let's let me just start down the line. Chris, I'm going to throw you a question. Well, you know what? Let me turn it over to Melissa, since this is from Minnesota, actually. So
no problem.
I have someone, Melissa, from Minnesota. Two-part question, looks like. They have a prenup, and in their papers it shows a property value of $883,000, when in fact the values for comps for that year were lower. She picked the figure, a higher figure. So I guess the question really becomes, what happens in a prenup? And my original thought, I'm curious as to yours, Melissa, is really the valuation absent fraud is irrelevant. I mean, there are usually some assumptions, and if you both relied on the value, albeit incorrect, and there was no nefarious intent to defraud or to, in this case, she picked a much higher value. I'm assuming that maybe she's going to get it. I don't have a lot of facts here, but if she's going to take that property, it may work to your benefit. If she picked a higher value to a piece that you're going to get, obviously, the mistake in fact may not work in your favor. But the court's really only going to look for fraud. So I'm not sure what you think, Melissa.
Yeah, it's an interesting question. Obviously, I would want to take a look at that prenup agreement and see what it actually says and how that value was determined. Who decided that? Was that a joint decision that was what it was going to be? And recognizing that there are changes in the market over time. So depending on how that was decided at the time versus how those changes occur, there's a lot of questions there. I think you'd have to actually look at the prenup to be able to tell.
You're right. And it is going to be prenup specific. And just as a follow-up question, this person out of Minnesota, their wife purchased a property in North Carolina in September. Now, this gentleman made the down payment. In Minnesota, what happens to that property? I'm assuming they're still married. So I guess he just wants to know what happens to the property if she put it in her name only.
Sure. So in Minnesota, anything that is purchased during the marriage is considered marital. So I don't know what it says. Again, because you have a prenup in here, it's a little bit different. It could say things about if you purchase property with X dollars, where those funds came from. All of those are variables here, but just generally speaking, if it was purchased during the marriage, it's considered a marital asset. So then it becomes a question of valuing it, who gets it in the divorce, putting it on that balance sheet. It doesn't necessarily matter whose name is specifically tied to it. But in Minnesota too, there's a property piece of it where because you're married, even if it's just in one person's name, the other person still has a property interest in it just because you were married solely for that fact.
And particularly with prenups, I think it's important to have that prenup evaluated by an attorney. There are ways, if it's not to your advantage, and maybe in circumstances that may call the prenup's validity into question. Timing is always one of them. Each party having an attorney's full disclosure, all kinds of things. So it's certainly worth a consultation to just determine whether or not there's validity to the prenup and what its provisions mean for you, especially in light like this. So Chris, all right, now I'm throwing it back to you. Clint has a question about less specific to retirement, but related to a business partnership, a 50-50 partnership that he has. It was formed in December of 2016 and does not have sustained and reliable revenue, but does have business assets or capital. Clint wants to know how to get a valuation of that business since it's a 50-50 partnership and what portion is at stake in the divorce process.
So if the 50, it's a great question. And what I always recommend, and I actually have a case currently going on where we have somebody who has a business where the other party actually has said that the business is losing money and they estimate the value around $1 million. Our client believes that the business is estimated around 7 or 8 million. So there's two different types. So it depends if the 50-50 partnership is between, if 50 is one spouse and 50 is the other, then the whole thing. If it's a 50-50 partnership, and it's going to depend on how the partnership is written up and specifically the legalese and the paperwork. But let's say one spouse, our client owns 50%. And then the other 50% is by a disinterested third party that has nothing to do with the divorce. Typically speaking, again, I want to talk in general terms, the amount that would be available for the court to divide would be the 50% owned by the client. My recommendation always is, in cases like this, is that you consult with your attorney, and through that consultation, talk to somebody who does business evaluations professionally. And usually when people come to me, we have people at Cordell that we particularly like to use in the area that are very, very good at business evaluations, because what typically happens is, and I've had this happen in the past, is that you go into court, and if you have a lot of speculation, the judges usually just sort of look at you with their eyes glossed over. But if you have a professional report from somebody that appraises businesses, they'll be able to tell you what they believe the business's future is and the business's present value. Yeah.
It is important to get someone, and you don't necessarily, what I like to do is even get a business valuator to give us someone we're not going to use in the case. So it's attorney-client work product and privileged. Hey, give us a snapshot, what's going on here. And we're not going to use them for the purposes of it. Yeah. So I think it's huge to just get a good snapshot of that.
That's a great tip.
Yeah. And Clint has just a follow-up question, and I think I can answer it, but is the 10% penalty waived on withdrawals from retirement accounts if it's used to maintain equity in keeping the house? There was, and obviously this is something you'd want to consult with your accountant or CPA as well. The CARES Act that last year did allow for some withdrawals up to $100,000, I believe, when used because of COVID hardships, particularly for whatever you needed. And so I'm just not sure with its applicability and extension into 2021, if the new COVID relief bill that was passed recently included an extension of that. But it's certainly worth checking with the CPA just to make sure that any withdrawals you do make before you make it are pursuant to that COVID relief bill under the CARES Act. So, all right, let's go on here. Let me pull up one more question here. Zachary, I'm going to throw this one to you. Let me get to it here. What is your perspective, Zachary, on using a mediator? And in addition, each party getting lawyers? What are the benefits and pitfalls with that method?
I would say mostly benefits. Mediation, in my opinion, is always beneficial. Even there are situations where you mediate and you might not be at a place to settle, but you can often use mediation as a discovery tool to find out information about about what the other side wants, what the other side's intentions are, you know, if you have questions about the estate, etc.
Mhm.
Having attorneys present, I'm an attorney, so I like to be there. But honestly, so we have mediators in Utah who just do mediations. I'm sure they have in other places. They don't have attorneys present, non-attorney mediators who just sort of are these third-party neutrals. And I often will get those decrees back a year, 2, 3 years later. And I look at the decree and I just think to myself, I wish this person would have talked with an attorney because he or she would have better understood his or her rights. So when you're making big decisions, and divorce is a huge decision, it shouldn't be hasty, and it should be planned, and it should be methodical, and it should be well informed. So mediating with attorneys present enables you to have that type of information right at hand. I mean, I've done mediations, I'm sure other people have as well, where you actually mediate, you have the mediator, attorneys, and then you have an expert come as well, either an accountant or a child expert or something, and to sit in and help the parties become as informed as possible when they're making decisions.
Yeah. I think that, you know, my perspective on mediation is I always recommend to our clients to do informal mediation. That is, I say, look, let's get the lawyers in one room and the clients in the room, and let's just mediate. Let's just see what's available out there. Let's just throw it out. Let's at least gather. We have to really kind of know what's available, what's there, have full disclosure, and then let's get in a room. Let's hash it out. Some people think in order to mediate, you have to have that third party neutral. You don't necessarily. I particularly say, let's try it on our own. Let's not add that expense of a third party neutral. Let's see where we get. I've gotten a lot of ground trying to resolve things. And as you suggest, Zachary, I think it's wonderful. I look at mediation as discovery. I really do. There are states and counties around the country. I'm licensed in Georgia, and at one point, mandatory mediation for 2+ hours was required. And I always told my clients, look, this is just an opportunity for us to hear their case, because they're going to inevitably tell us what they want and why. And so let's just go with an open mind and listen. We don't have to settle. It's just an opportunity to just see. So it's a good question, good answer. Cara, Andrew has a question about Social Security funds and wants to know whether or not he should just offer those to the daughter and mother without first securing an attorney. They're not necessarily on good terms. He just doesn't know whether or not he should just make an offer using his Social Security to calculate child support. I know what I would say, but I'm curious what you have. Go ahead.
Well, I think there's probably more questions I have than just that. But I think for Pennsylvania purposes, Social Security is considered income. So if we're talking child support, you would take whatever your Social Security income is, and that is what essentially would be like your pay stub. But the thing is that if you were married to opposing party, she could, it goes a little bit deeper. She can technically collect a percentage of what your Social Security is. So she might have the same amount at some point. You know, we would need to figure out ages and where everybody's at in their life and things. And then also if it's Social Security disability, I just actually dealt with this yesterday, and the child's under 18 and one parent is receiving disability, they're also then receiving a derivative benefit for that child, which then should be considered as part of your income as well. So I think there would be a lot more questions than answers there, but I hope that helps.
Yeah, I mean, it's just complicated, and I'm not a fan of. There are many states around the country that have child support calculations. Oh, it's just a formula. But there's also, for example, here in Missouri, where you can deviate from the child support chart for a number of reasons. And so just offering this amount of money without knowing really, what I like to present to the client is best case, worst case, and likely. And here's what we can do to argue to come off chart. And typically it has to do with visitation, overnights, how much time do you spend? At least be equipped with the knowledge before you go on your own to try to resolve it without an attorney. At least spend an hour, go in there, figure out what is likely to happen, and then and then you can try to negotiate for less, because both of you have an interest in not getting an attorney, and say, look, here's what's going to happen if we go to court. But in order to do that, we both have to spend money. So let's settle for something less. So it's worth knowing rather than you just throwing it out there. And as Cara suggests, it depends on what it is, because she may be peeling off a part of that Social Security benefit, and in fact, she's double dipping then. So I think that's a good point to just set a consult and come on in. So let me go to Melissa. How does the math for division of assets work for a spouse who is a stay-at-home parent?
That's a great question. So obviously some of it's going to depend on the state that you're in, but in Minnesota, what we look at is what's considered marital. And that means what is from the time you got married to the valuation date that we choose for purposes of the divorce. And so if, one parent has been putting away into retirement, they've been the person that has the best credit for purposes of buying a house or buying vehicles, putting the loans in their names. Obviously, those things are going to be in the person's name who has been working, but that doesn't necessarily mean that they get stuck with all of it. So the conversation then becomes, what is that stay-at-home parent's ability to take on a loan? So for example, if you have a stay-at-home mom and you have a big family and you've got this big giant Yukon that she can't afford to keep because she can't make those payments on a monthly basis, is that a part of a spousal maintenance conversation? Is that sell that vehicle and get us something smaller that will work better, that can be affordable? Is it, dad now gets that vehicle and mom gets a different vehicle? There's a lot of different considerations there, but the division of assets, at least in Minnesota, the way that the statute is written, is considered equitable. And a lot of times that doesn't mean equal, but it may mean, if dad keeps these things and mom keeps these things, where do we end up at the bottom line? And then we figure out who needs to transfer money to who.
Yep. All right, Chris, the question is how are taxes paid for 401ks and who pays them?
Oh, so very good question. And I want to say it's going to depend on obviously when you take the 401k out, and usually it's going to be divided up in theory by the taxes are, if the 401k is divided, so whichever party gets which part of the 401k is probably going to pay taxes on that. But there's two important caveats, and one was something you mentioned earlier, which I think is great advice. The first one is you can actually adjust that. So believe it or not, I actually had to step away earlier because we have a very contentious issue coming up where we had a division of this, and now it has come back that the taxes filed in 2015 were incorrect. So it's really, really, really important that you have a stipulation or some type of language in your divorce decree as to who is paying the taxes now, or if there's any tax errors on any amounts that are divided. And again, going back to what you said earlier, Scott, which I think is great advice, I always tell people when it comes to tax issues, even when we have that in language, it's never a bad idea to talk to a tax professional just to double check, because like you said, especially with COVID relief, you have stimulus money, you have all these different factors. Tax law is always in flux, and it is always, always good to double check, especially when it comes to paying taxes on retirement accounts.
Yeah, my least favorite class in law school, 28 years ago, was tax.
Exactly.
I can speak a little bit on it, but I'm certainly not the one to give the advice. So we always work with a professional to make sure that when it comes to the IRS, we're on solid ground. So
sure.
One question was whether or not someone can use our tax and benefits department. Is there a charge? And certainly they just charge, and I'll answer that quickly. They just charge for the work performed. And that is if they're doing an analysis or they're doing a quadro or a domestic relations order or division, it's straight hourly, and anybody can come on in and retain or consult with our tax and benefits department. So let me turn this one to Zachary. Can I depose my ex-wife to confirm I paid child support obligation during my first marriage? Apparently there may be some dispute as to whether or not that was ever paid, perhaps to get a credit, but I'm assuming that general terms discovery, they want to know whether he can use a deposition to go and talk to his ex-wife.
That's a great question. So typically a deposition is a discovery tool that is implemented or used when the case is fresh, when the case is going. So if someone files for divorce and then there's a discovery period. So in your specific jurisdiction, there may be an issue with being able to do a deposition. If you tried to schedule a deposition and there wasn't some ongoing case, then the opposing party may object to that. However, if you are, my guess is this has come up on some sort of, it could have come up on some sort of contempt or enforcement issue or a petition to modify or something. If there is some sort of dispute before the court, then by all means, I see no problem with doing a deposition. In fact, it seems like a great idea, especially if you don't have records. I'd say the best of the evidence would be records. Go to your bank, or if you're having if you're paying cash or If you're paying cash, it's going to be kind of difficult to get records, obviously, but records, number one. Number two, deposition sounds fantastic.
Yep. Melissa, if one spouse has significantly more funds in an IRA than the other spouse, and they're both IRAs, do you divide everything, or do you just allocate the differences, and do you still have to do some sort of DRO, QDRO?
That's a great question. So typically what I would say is if you've got one person that has a lot more than the other person, offset them. A lot of times when we put our balance sheets together, we do that even with all of the assets. We say if this person gets this much and this person gets the other, how do we divide them? So you don't necessarily have to do, this IRA gets split in half and this IRA gets split in half and you guys trade money. You can offset them for the most part. And like I said before, you may need a quadro depending on the IRA, but for the most part, you wouldn't need to do a quadro. You would just need, I think they're called the letters of instruction or something like that, that you would just transfer whatever the amount is to the other person's IRA.
Cara, are there situations where a spouse would not be entitled to a portion of the other spouse's IRA?
Well, I think it depends on the state, obviously, but it also depends on defenses. So IRA retirement plans, I don't think necessarily. However, infidelity can come into play with things such as support and alimony. So that's always something to take into consideration. I always have clients ask, where can we bring this in? And I always say, I think the biggest thing is for that to come into play for support and alimony, not necessarily the IRA or other retirement plans. However, if one spouse I could see, dissipated an asset or something like that, I think then that could rule out any kind of obligation to have to pay out of an IRA as well.
All right. Let's go to Chris. What part of my 401k is she entitled to? Half my contributions during the marriage or half of what they're worth?
So again, kind of dovetailing off what Cara said, it's going to be very, very dependent. So in Kansas, for example, everything, it's not a complete 50-50 equitable split. So in Kansas, it is up to the court to determine what is a fair and equitable distribution of assets. So saying what someone is entitled to, my answer would be they're not entitled to anything, but they may be able to get a large portion of it. So the court's going to look at everything that was accrued or acquired during marriage, and then they're going to look at what's the most equitable way to divide it. So for example, in Kansas, the court may say, I'm going to give 70% of a person's 401k to the other party because the person who's only getting 30% has significantly more earning power and has more opportunity to contribute to that 401k. So I would say entitled, I wouldn't say anyone's entitled to anything, but I think it's important that a very large portion or all of the 401k in most states could be vulnerable. And again, that's why you're going to want to get an experienced attorney to really do a little bit of a deeper dive into the sources of the funds for the 401k and its current status.
Yeah. Okay. I got probably enough for one or two more questions. I'm going to answer one real quickly, and that was, I'm planning to file for divorce in April. Should I file my 2020 tax return jointly or separately? Really a couple considerations. One, again, speak with your tax professional. Make sure and see what is appropriate. What's the penalty if you're going to file, or the gain if you file joint or separate. Two, you want to make sure you consult with your spouse and making sure you put them on notice. You don't want to do some action by filing separately when they file jointly, triggering an audit, no doubt, or creating a situation where you benefit and that they get a detriment to it by filing, separately or whatever it may be. So you want to put them on notice that, hey, I'm going to go ahead and file separately. It's in our best interest, those types of things. And then three, really want to consider all things about, you were classified as married as of the last day of the year in December 31, 2020. So technically you're going to file joint or separate. It also will impact your stimulus if you're eligible for the stimulus and the COVID relief. So you want to consider that as well. So it really is sit down with not only your attorney, but also your tax professional, make the most, I guess, a relevant financial move as you go through it. So let me ask one final question to Zachary that came in, and that is a Colorado question. My kids have lived with me ever since my ex left 2 years ago. She has recently decided she wants the kids to live with her. So she claimed domestic violence and the court granted it. My kids are now living in a 2-bedroom home with 10 other people. What can I do to get them out of that situation?
It's a good question. Those situations are, in my opinion, the most tricky. So you're likely going to need a third party to come in my opinion, to come in and basically do an evaluation. most jurisdictions have custody evaluators that will come in and they'll meet with you, they'll meet with the other party, they'll meet with the kids, and they'll make a determination. Ultimately, across the country, definitely in Utah, a court's objective is to accomplish what's in the kid's best interest. I think most people are interested in accomplishing that same thing. And so really the task is just to point that out to the court that it's in the kid's best interest to be with you. So if, depending on what sort of action resulted in the kids going or switching custody, it's kind of surprising that they were with him for 2 years and then switched. So I think sounds like there's definitely some, I think that has legs perhaps, but
yeah, it could be that you file a divorce action with a temporary motion trying to, show an unsuitable living environment. There are a lot of options. I think it is unusual, especially given that a court entered it. I think it's one of the more abused statutes in the country where you can just go make an allegation without proof, just write it down and you get it. So it means you just got to get a lawyer, period. Have that consult. One final question, and I know we're over time, but Melissa, I'm going to throw it to you and I'm going to speak to it quickly. Deferred comp, how is that handled? Is it different than retirement? Obviously, to me, it's income. It's just deferred income rather than guided by the ERISA rules, the Employee Retirement Income Security Act. So it's not a federal necessarily, but how do you deal with deferred comp issues in a divorce?
That's a great question. But because we are running out of time, I kind of want to hit on one small thing. We are all getting stimulus checks coming in right now, and we've got clients that are dealing with that issue. So with just the last minute that we have, I just wanted to say that you want to make sure that you're talking to your attorney about whether or not you received it, whether or not your former spouse received that, whether or not you're entitled to any part of that for your kids' benefit, who filed taxes, who claimed the kids on dependency exemption. So just be sure that you're talking to your attorneys right now about whether or not you should be getting any of those funds.
Yeah, I mean, especially they're rolling into bank accounts now. You want to make sure that you protect yourself, get what's due you, split it, whatever it may be. What do you do with it? If you get the whole payment, you're in the middle of a separation or divorce, what do you do with it? It's a good point, Melissa. So I know we're way over time. So that is all the time we have. We'll address the questions. We have a number of them that came in during the podcast next week, which we do twice each week. I want you to subscribe. Go ahead and subscribe to that podcast. You'll get alerted when there's something new posted. We do it twice every week. I want you to do that. Also look for the April town hall. Go to Cordell Cordell. You can register for that. Tune in, ask questions live of our panel, just like now, and get answers right here, right then. So also submit your questions to townhalls@cordelllaw.com. That is townhalls@cordelllaw.com. We'll address your questions. Get to those in the podcast that we do every week, twice each week. Again, thanks for joining our virtual town hall and to our panel for providing their insight and education to you all. And we look forward to seeing you. And until next time, have a great week.